Hello there. My name is Dr. Julia Osman. I'm the director of the Institute for the Humanities, and I'm thrilled to welcome you all to this program called Reproductive Rights in the Age of COVID. And here we'll be talking about what the new abortion law in Texas means for us here in Mississippi. I'm joined today by Dr. Kimberly Kelly, who is an associate professor in the Department of Sociology here at Mississippi State, and she's also the director of gender studies here. As we move forward, I will just let everyone know that if at some point during the presentations of our two speakers, if you have questions or if you have comments that you would like the speakers to address, just please put those in the comments section underneath the video that you're watching right now, and we'll do our best to incorporate them into the conversation during the question and answer period a little bit later. And with that, Dr. Kelly, thank you so much for being here today and for suggesting this program and for bringing your colleagues with you.
Julia, thank you so much. And thank you to Dr. Osman, John Burrow, Brian Tesh, the Institute for the Humanities, and the College of Arts and Sciences for partnering with the Gender Studies program to present today's talk. I hope it is the first of many fruitful collaborations. And I'd also like to give a shout out to Karen Brown and the entire communications team in the college for helping us publicize this important event. So what I'd like to do now is introduce both of our speakers, tell you a little bit about what they're going to talk about today, and then turn it over to the experts. Carole Joffe is a professor in the Department of Obstetrics, Gynecology, and Reproductive Sciences at the University of California at San Francisco, as well as a member of the research group for advancing new standards in reproductive health, nicknamed ANSWER. Dr. Joffe's research spans a variety of closely connected topics, including sociology of reproductive health and reproductive politics, sociological aspects of abortion provision, gender and public policy. Her most recent book, co-authored with Professor David Cohen, is Obstacle Course: The Everyday Struggle to Get an Abortion in America. In addition to dozens of articles, chapters, and op-eds, she is also the author of several additional books, including, but not limited to, The Regulation of Sexuality, Experiences of Family Planning Workers, Dispatches from the Abortion Wars, The Costs of Fanaticism to Doctors, Patients, and the Rest of Us, and Doctors of Conscience, The Struggle to Provide Abortion Before and After Roe v. Wade. Dr. Joffe's contributions to academic and public scholarship are widely recognized, and she is the recipient of the David Gunn Lifetime Achievement Award from the Abortion Care Network, the Lifetime Achievement Award from the Society of Family Planning, and the Irwin Kushner Lecturer by the Association of Reproductive Health Professionals. David Cohen is a professor of law in the Drexel University Klein School of Law. Professor Cohen's work addresses a number of important topics, including the intersections of constitutional law and gender, how the law impacts abortion provision, including violence against abortion providers, sex segregation and masculinity, and voting anomalies in the Supreme Court. In addition to Obstacle Course, which he co-authored with Dr. Joffe, he published an earlier book, Living in the Crosshairs: The Untold Stories of Anti-Abortion Terrorism, with former student Kristen Connon. Professor Cohen has published articles and chapters in such prestigious outlets as Harvard Journal of Law and Gender, Columbia Journal of Gender and Law, and edited volumes including the Feminist Judgments series. Professor Cohen has argued before the Supreme Court, worked as a research assistant for Kimberly Crenshaw, and later as a staff attorney for the Women's Law Project of Philadelphia. He has won 8 teaching awards in the last 12 years. Professor Cohen's scholarly and legal work is also widely recognized, and he is the recipient of the Center for Reproductive Rights Innovation and Scholarship Award and the 2016 Person of the Year Award from the Abortion Care Network. Today, Dr. Joffe and Professor Cohen will be addressing a number of critical and timely topics, including the effects of the global pandemic on abortion access and exceptionalism, as well as the status and effects of the Texas law, Texas abortion law, SB 8, and the Mississippi abortion case that will be argued at the Supreme Court on December 1st. SB 8 bans abortion at 6 weeks since a woman's last menstrual period, so about 4 weeks after conception. It allows private citizens to bring civil suits against anyone who helps a woman get an abortion, such as the physician who performs the abortion or somebody who helps a woman pay for the procedure. And when those people are sued, they may, the person who has brought suit may be able to collect at least $10,000 in damages if they prevail in court. The law has been challenged by abortion providers and the Department of Justice, but is currently still in effect. The Mississippi case, Dobbs versus the Jackson Women's Health Organization, addresses the 15-week abortion ban in Mississippi. When the court agreed to hear Dobbs, it diverged from precedent in agreeing to hear a case that addressed a pre-viability abortion ban. Such abortions are currently protected under law by Roe v. Wade, which legalized abortion across the country in 1973, and upheld by Casey v. Planned Parenthood in 1992. I am very, very much looking forward to hearing our speakers' thoughts, as are my colleagues, and we welcome Dr. Joffe and Professor Cohen to Mississippi State University, albeit virtually. Dr. Joffe, I believe you are speaking first.
Dr. Joffe, I think you need
Yes.
to unmute yourself. Okay.
Yes, I just got that message. I was talking to you guys before. Anyway, whatever. I think I have demonstrated to this group that technology is not my best thing. Anyway, I'm really delighted to be here. I thank you, Dr. Kelly and Dr. Osman, for this very nice invitation. Last month, I had the great honor of speaking to Dr. Kelly's very smart students, and I'm glad to be back. So I'm going to speak to you today about abortion exceptionalism and COVID. And John is going to show my slides. Thank you, John. Right. I'm going to talk about abortion exceptionalism, and I'm going to use the case of COVID-19 to better help you understand by what we mean by this concept. So the next slide, John, please. So this comes from the book David and I wrote, Abortion. It was an important concept for us in this book. The idea that abortion is regulated both differently and more stringently than other medical procedures that are comparable to abortion in complexity and safety. Well, first of all, let me say, coming to Mississippi to tell you that abortion is regulated differently and more stringently might sound somewhat demented. You presumably know this already. So I am speaking more generally here. I get it that Mississippi is regulated stringently. Okay, but this concept has been used often in legal contexts, and it obviously makes sense. If you look at the definition here, medical procedures that are comparable to abortion in complexity and safety. This issue came up, for example, in the last one of the best Supreme Court decisions we had in 2015 with the whole women's health decision, when the Supreme Court then pointed out that why should abortion providers have to do things that other healthcare providers of comparable complexity, outpatient surgery, for example, colonoscopies. So this concept obviously makes sense in a legal context. But what I'd like to do for you today, and I should stress I am a sociologist, even though I work in the Department of OBGYN, I'd like to give this a broader sociological meaning and suggest to you that abortion exceptionalism really goes beyond the bounds of the legal and the regulatory. And John, could I ask for the next slide? Yeah, so last summer, a year ago, this past summer, the first summer of the pandemic, I joined a number of colleagues at Answer, and we did interviews with people across the country, although we really look to red states because that's where most of the interesting stuff happens. How was abortion care happening during COVID? All healthcare institutions in the immediate aftermath of COVID, all of them obviously had tremendous difficulties. I would assume most of you on this call know that. Difficult to get to a provider, a lot of telehealth, a lot of concern about what was safe. If you were so unfortunate to have a loved one in a hospital, you couldn't visit. So please don't hear me as saying only abortion providers had problems. What I am saying is abortion providers had the same problems as all other healthcare providers, but even more because of abortion exceptionalism. And let me give you some examples of what I mean by this. So for example, the first quote here comes from a provider in a doctor in a state where the governor had used, as did a number of other governors, used COVID, used the pandemic as an excuse to shut down abortion clinics, saying they were not essential health care. Ultimately, various lawsuits were filed, and ultimately the clinics were allowed to reopen. But abortion is essential health care for people who want and need abortions. So here, that first quote can suggest to you the kind of chaos that happened, in these clinics, never knowing from one minute to the next, are we open now? Are we not open now? Which, by the way, happened very recently in Texas, and David might get to that. There was a very brief window when the Texas clinics opened, but then they had to shut again. Will they retroactively be sued? Well, I'll leave that to David. But here we see the same kind of chaos. Patients in the waiting room, waiting to be called. A lawyer calls and says, "Wait, stop, send everybody home." That was enormously difficult, obviously on the patients, but on the clinic staff as well. I spoke to a doctor who was distraught. Two of the patients that they were seeing that morning fell through the cracks. They were, by the time the clinic reopened, these two patients, one of whom was a homeless woman, the other was a young teenage woman who had very serious health issues. By the time the clinics reopened, these two individuals were over the gestational limit. So it was very stressful. The next quote, I have one doctor, if she gets sick, I'm toast. This quote reinforces to you not simply the shortage of abortion providers, but how they are geographically maldistributed. Many abortion clinics, including, I believe, the clinic in Jackson, Mississippi, have doctors who fly in because for various reasons, local doctors either don't want to provide there, or even if they do, are afraid of what it means to live in a hostile community and provide abortions. Will your kids get screamed at? Will your fellow doctors shun you and impose sanctions against you? So I mean, having your doctors fly in a period in which flights were being canceled right and left, in which doctors themselves were afraid of travel because of the health consequences, yet another example of the chaos that COVID brought. Now, let me be clear. Yeah, John, if we can, yeah, that's good. Let me be clear. It's not only abortion care that has a shortage of providers. As you likely know, living in Mississippi, which has rural areas, there's shortages of rural providers as well in other fields. I think a real difference here, and again, we see the power of abortion exceptionalism. I mean, from a patient's perspective, if there's no local clinic around, and we know there's 6 states with only one clinic, if you're in a rural situation, and for example, let's say you need to see another doctor for regular non-abortion care, it's no doubt inconvenient, but you can ask somebody to drive you. With abortion, given the stigma, given the huge political baggage that accompanies abortion, it's not so simple to ask somebody to drive you. So again, similar problems to other healthcare institutions, but because of the cultural, political power of abortion, much more difficult to negotiate. Now, as I'm sure you all know, during the pandemic and continuing to the present moment, telemedicine has really come into its own for obvious reasons. You can, if you don't physically need to be in the presence of a doctor to explain your situation, telemedicine has been a wonderful partial solution to what COVID has brought. And in fact, even before COVID, telemedicine was starting to be used, as it was in other healthcare areas, starting to be used in abortion care, made things a lot simpler for people who live very far from clinics. However, 17 states, and I believe Mississippi is one, and I'm sure Dr. Kelly will correct me if I'm wrong, ban the use of telemedicine, even when they use it for other things. Texas, for example, huge state, widely use of telemedicine, but surprise, surprise, knowing what we know about Texas, doesn't allow it for abortion care. Finally, if you look at that last quote there, we had to tell our escorts to stay home. Our protesters are out of control. They don't social distance. They harass our patients. Here you see on no uncertain terms what abortion exceptionalism means in this context. I can think of no other aspect of healthcare where you have protesters and you need escorts. Individual doctors, individual hospitals, certainly there's isolated instances of being targeted if for whatever reason, but these are for particular individuals or particular institutions. It really is only abortion where virtually every abortion clinic in this country has experienced some degree of harassment. And obviously the clinic in Jackson, the Pink House, is no exception. One way of dealing with the harassment brought by protesters is the use of escorts, which have become a very, very important part of abortion care. Escorts come to the clinic, stand in front of it, literally escort the patient away from people screaming in her face or trying to photograph them or whatever. So escorts have played a huge role. However, abortion clinics, being responsible at the beginning of the pandemic, told the escorts to stay home. The protesters did not follow public health guidelines, to put it mildly. They came, they harassed patients. A lot of, as the quote says, a lot of clinics, in order to minimize the time that patients spent in the clinic, had patients wait in their cars, those who had cars, and then would just text them, okay, now we're ready to see you. So here are these patients sitting alone, or sometimes with family members, sometimes with their little kids because they'd had no childcare. And here are patients literally swarming, here are escorts swarming, all over the place. So this has been extraordinary. I mean, it's always an issue with protesters and how much upset they can cause. Dave, as Professor Kelly mentioned, David has written an excellent book about this, but during COVID, it was especially difficult. Okay, final slide, please, John. Okay, and here's a more subtle version of abortion exceptionalism. What I'm trying to get across with these quotes is is how the normal conventions of abortion care have been impeded by the pandemic. So the first quote comes from a counselor who used patients used in this particular clinic. Patients used to be counseled as you might imagine, in an office meeting face to face. This clinic has small offices. The director very reasonably said, look, we can't have you, a counselor and a patient together. You be in one office and let's have the patient be in another. Now, again, other healthcare institutions no doubt did the very same thing. My argument to you is that because of abortion exceptionalism, this matters more. In other words, most patients don't come, they might be somewhat fearful of the procedure, but they don't come to a clinic terrified that their parents will find out. They don't come to a clinic having to walk through people screaming at them that they're murderers and that they'll go to hell. One of the main protesters in North Carolina, a well-known figure in the anti-abortion world, also in Texas, and for all I know, he's shown up in Mississippi. I mean, my least favorite quote is, Satan will drink the blood of your dead babies. You go into a clinic having heard that, you are very likely going to be shaken up. A counselor's job is to soothe you, is to reassure you, to tell you you're not going to go to hell if that's what you've been told, and perhaps part of you believes that. So here again, because of the special circumstances of abortion, this is a particular loss. The second quote comes from a doctor who told me, quite regretfully, I was asking her, well, what's it like to do abortions during COVID? And she said, now I don't come over to give their hand a squeeze or give them a hug if they're receptive to it. Now, again, other doctors in other contexts also want to be very warm and invite. I mean, some do, some don't, obviously, but assume there's a class of doctors who similarly want to reassure their patients and give them a squeeze or give them a hug. They can't do it either during COVID. My argument to you is, because of the special nature of abortion, because of the social conflicts that swirl about it, my argument is that this kind of reassurance is arguably more necessary in the abortion case. So that ends my remarks. Thank you very, very much. And I look forward to people's questions, and I look forward to David's presentation.
Thank you, Carole, for that discussion of abortion exceptionalism. It's nice to see everyone, and thank you to Mississippi State and everyone there for hosting us, albeit virtually. I'm going to talk now about the legal issues around abortion, and we are in a hot year for legal issues around abortion, for better or for worse. So I'm going to talk both about the Mississippi case, Jackson Women's Health Organization v. Dobbs, and the two cases before the Supreme Court around SB 8, the Texas law that's been so much in the news for the past couple months. So just to set the stage, the usual way that anti-abortion laws work is that a state restricts abortion, and there's all sorts of restrictions on abortion. The book that Carole and I wrote together goes through all the different ways that states restrict or ban types of abortions. Usually these are done through the criminal law, where states ban a particular type of abortion or abortion after viability, and that is enforced by state prosecutors. Or there are regulatory requirements where an abortion provider has to jump through a certain number of hoops or do certain things before providing an abortion. And that's enforced by state licensing or administrative bodies. Now, these laws, when they're passed, the clinics tend to challenge these laws as violating the Constitution. And they sue usually before the law goes into effect. And what they do is they file a lawsuit before the law goes into effect against the state officials who are responsible for enforcing the law. They usually sue in federal court, sometimes in state court, but usually in federal court against the state officials. Now, technically, they are not allowed to sue the state. You can't sue Mississippi, for instance. You have to sue the person responsible in Mississippi for enforcing the law. That's why the Jackson Women's Health Organization case is against Dobbs, the health commissioner, not the state of Mississippi. And so that's how abortion laws usually are enacted and usually are litigated. And the law in Mississippi that's at issue in the Dobbs case is one of these ordinary laws around abortion. It's not ordinary in what it does, but it's ordinary in the way it's structured. So in 2018, Mississippi passed a ban on abortion at 15 weeks gestation. So viability tends to be around 23 or 24 weeks. So 15 weeks is well before a pregnancy is viable. And Mississippi banned abortion at 15 weeks. Now, the only abortion clinic in Mississippi, Jackson Women's Health Organization in Jackson, does abortions through 16 weeks of gestation. So this meant that the patients who went to Jackson Women's Health Organization who sought an abortion after between 15 and 16 weeks were now prohibited from doing so. This was an ordinary anti-abortion law in the sense that the state was responsible for enforcing it. So the clinic, Jackson Women's Health Organization, sued, saying that the law violates Roe v. Wade and Planned Parenthood v. Casey. Now, they were mentioned at the beginning, but just a basic idea. Roe v. Wade is the case from 1973 that says that a state cannot ban abortion. That would violate the Constitution. It said some other things, but for our purposes, that's what's important. And in Planned Parenthood v. Casey, 1992 case out of Pennsylvania, where I am, the Supreme Court adjusted Roe slightly, or maybe a little more than slightly, and said that a state can regulate abortion as long as the regulation does not provide or create an undue burden or a substantial obstacle on someone choosing to have an abortion. And it can do that before viability. After viability, a state can ban abortion as long as there's an exception for the patient's health or life. And viability, like I said, was around 23 or 24 weeks. So before viability, before 23, 24 weeks, the state can restrict abortion, but cannot ban abortion. That's the rule from the combination of Roe and Casey. So a ban on abortion at 15 weeks, like Mississippi enacted 3 years ago, clearly violates Roe and Casey. There's no doubt about that, and no one really is arguing otherwise. The lawsuit against this law, the trial court struck the law down as unconstitutional, said that it clearly violates Roe and Casey, and Mississippi appealed, and it went to the Fifth Circuit. The Fifth Circuit is the federal court, the federal appeals court, that covers Mississippi, Louisiana, and Texas. It is probably the most conservative court in the country in terms of an appellate court. It is very anti-abortion, the judges on the Fifth Circuit. But the Fifth Circuit also agreed that the Mississippi law was unconstitutional. It is so clearly unconstitutional that even the Fifth Circuit agreed that it's unconstitutional under current Supreme Court doctrine. So Mississippi appealed again to the Supreme Court, and this time to the Supreme Court, with the hope that, well, the Fifth Circuit can't change the Supreme Court rules, but maybe the Supreme Court can. And so Mississippi appealed to the Supreme Court, and now the Supreme Court gets to choose which cases it takes. So the Supreme Court did not have to take this case. It could have decided, well, it's very clear that this law is unconstitutional. There's no need for us to take this case. But after spending months and months debating whether to hear the case, the Supreme Court meets almost every week to decide what cases it's going to hear. And it met 20 different times, or over 20 different times, to determine whether it was going to hear this case. That is highly, highly unusual. It finally, on May 17th of this year, agreed to hear this case, and it agreed to hear this case to address one question: whether all pre-viability prohibitions on elective abortions are unconstitutional. So the Supreme Court agreed to hear this big picture question of whether states can ban abortion before viability. Over the summer, the briefing was completed in this case. Mississippi asked the Supreme Court directly to overturn Roe v. Wade. They didn't try to, whittle away at the edges by saying you can approve this, but uphold Roe. Mississippi just directly attacked Roe v. Wade and said it is time for the Supreme Court now, 48 years after Roe v. Wade, to overturn this precedent. The clinics filed their briefs, and the clinic and its supporters filed their briefs saying that this law would open the door to banning abortion entirely. It's not just about a 15-week ban, it's about the possibility of banning all abortions. And so the briefing was done over the summer. The oral argument is on December 1st. So in less than 3 weeks, or just over 3 weeks, the court will be hearing oral argument in this case. And it will be one of the most watched cases in decades because this is a direct attack on Roe v. Wade, which is what the anti-abortion movement has been looking to do for a long time. Now, they've done this before with a direct attack on Roe, but they think their chances are higher now because the court's makeup has drastically changed in the last several years. Carole mentioned the Whole Woman's Health case decided in 2016, in which the Supreme Court struck down an abortion law out of Texas. And then there was a June Medical, a case decided last year, where the Supreme Court struck down an abortion law out of Louisiana. And you may think to yourself, well, 2 cases in the past 5 years, the Supreme Court has struck down an abortion law. This seems like a Supreme Court that is not looking to end Roe. Well, the change happened last fall when Justice Ginsburg passed away a month and a half before the election, and President Trump rushed through the nomination and confirmation of Amy Coney Barrett. Justice Barrett is now on the court, and she is widely believed to be an anti-abortion conservative. And that drastically changes the Supreme Court because you go from Justice Ginsburg, who is pro-choice and always voted pro-choice, to Justice Barrett, who she hasn't addressed an abortion case yet, but presumably will decide against abortion rights. And now you have 6 justices on the court, a 6-3 court, 6 of whom are conservative, Republican, probably anti-abortion justices. And so this case now comes before a very different Supreme Court. And again, that's going to be heard 3 weeks from tomorrow, and it will be live streamed on the Supreme Court website for anyone to listen to. You cannot watch it. It's not video live streamed, it's audio live streamed. It'll be 10 o'clock a.m. Eastern time on December 1st. Just go to the Supreme Court website and the link will be right there for you to listen to it. Meanwhile, in Texas, SB 8, which has been all over the news for the past several months. SB 8 stands for Senate Bill 8. It was passed May 19th this year to take effect September 1st. This is a very unusual law, and Dr. Kelly highlighted some of the ways in the introduction, and I'll just repeat them now. This law bans abortion at 6 weeks. Now, just to be clear, 6 weeks is a technical term. 6 weeks in pregnancy is measured from the last menstrual period. So it's 4 weeks after conception, if someone is on a regular cycle, 4 weeks after conception, and only 2 weeks after someone might first realize they missed their period. And that's if someone is regular and very attuned to their body. So this is a very short period of time for someone to decide to have an abortion and then find an abortion provider and get one. Well, the law bans abortion at 6 weeks. That part of this law is not unusual. There are many states that have tried to ban abortions at 6 weeks, including Alabama, Georgia, Ohio, and several others. All of those laws have been struck down as unconstitutional because they were typical anti-abortion laws, making it a criminal violation to perform an abortion after 6 weeks. So the lawsuit, like the ones I talked about earlier, went forward, nothing that complicated there. What SB8 does is change the entire system or procedure for enforcing an abortion ban. Rather than the state being involved through licensing or prosecutors or other government bodies, the state is not involved at all for SB8 enforcement. Rather, private individuals can bring lawsuits, just like if you're in a car accident, you can bring a lawsuit. Private individuals can bring lawsuits against a doctor or anyone who aids or abets the performance of an abortion. And that is left intentionally vague. So who is aiding and abetting an abortion? Well, certainly the nurse and the administrators who are at the clinics, but your friend who tells you about where to go to get an abortion, your insurance company that pays for the abortion, your sister who drives you to get an abortion. These are questions that are up in the air, how broad this aiding and abetting is. So private lawsuits against the doctor or anyone who aids or abets the performance of an abortion after 6 weeks. And these lawsuits can be brought by anyone, literally anyone, not just, say, the partner of the person who's pregnant or their family member who's upset they're getting an abortion. It is anyone in the world, not just anyone in Texas, not just anyone in the United States. It doesn't have to have any connection to Texas, the clinic, the patient. Anyone can bring this lawsuit. And they can bring this lawsuit for $10,000 or more. There's no upper limit on this lawsuit. It is a minimum of $10,000. This is private bounty enforcement for violating Texas law. This is highly unusual. And as a general matter, this is not how law is done in this country. There is not this kind of unlimited private enforcement of law by people who have no connection whatsoever to the problem or the identified so-called problem. So the clinics were the clinics in Texas were in a situation where they had to try to figure out what to do about this law. Normally, they would sue the state officials, like the clinic in Mississippi did, like Jackson Women's Health Organization did. Normally, they would sue the state officials, but the state officials aren't involved in enforcing this law. So they had to figure out whom to sue. So in July of this year, they decided to sue the judges in Texas and the clerks at the courthouses in Texas, under the theory that the clerks are the ones who would be receiving the lawsuits and the judges would be the ones who would be deciding these lawsuits. And they sued them saying, it is unconstitutional for you to docket these cases and decide these cases, because to do so would infringe upon the rights of the patients. This was a novel theory because this is a novel law. Now, the federal court in Texas that was assigned this case was scheduled to hold a hearing on the law on August 30th, 2 days before it went into effect, to decide whether to stop the law before it goes into effect. The Fifth Circuit, which I previously told you is this very conservative anti-abortion court, put a hold on this hearing, didn't even let the court hold the hearing, saying that you can't hold this hearing because we want to consider this issue in depth sometime down the road, but did not put SB8 on hold. So the clinics appealed to the US Supreme Court, and the US Supreme Court, on an emergency basis, sat on this case for a couple of days. It let SB8 go into effect. It did not decide anything on August 31st. So the morning of September 1st, SB8 went into effect in Texas. And then the night of September 1st, right before midnight, the Supreme Court, in a 5-4 decision, basically said, this case presents some really interesting novel questions. We can't do anything about it now, so SB8 is allowed to take effect. So SB8 took effect, and since September 1st, there have been no abortions past 6 weeks in Texas. We are now at 70 days and counting in which abortions after 6 weeks have been illegal in Texas. For the most part, clinics have not been disobeying this law. There's one doctor who announced publicly that he disobeyed this law, and he was sued, and those lawsuits are pending. But otherwise, the clinics have been complying with this law, leaving people in Texas who want an abortion after 6 weeks the two options, really, or three options. One, they can carry the pregnancy to term. Two, they can try to obtain an abortion through illegal means by illegal methods or self-managed abortion. Or three, they can travel out of state. All of these things are increasingly difficult depending on how many resources you have at your disposal in Texas. The clinics eventually got fed up with the Fifth Circuit delaying even more, and they went back to the Supreme Court asking the Supreme Court to act, and filed another a request for the Supreme Court to act. I'll put that on hold because in the meantime, the United States stepped in. The Department of Justice, the Biden Department of Justice, stepped in and sued Texas directly. Now, unlike the clinics that are not allowed to sue the state as a general entity, the state, and has to sue the officials, the United States is allowed, under complicated issues of law, allowed to sue the state directly. So the United States sued Texas under the theory that Texas passed this unconstitutional law and the United States needs to stop Texas from enforcing this unconstitutional law. The judge held a hearing in early October, and on October 6th, the judge said SB 8 is looking like it's unconstitutional, so we're going to put this law on hold. 2 days later, the Fifth Circuit again put the judge's ruling on hold and allowed SB 8 to go back into effect, and the Justice Department appealed to the Supreme Court. So now we have two appeals to the Supreme Court. And on October 22nd, the Supreme Court said that it would hear both cases, and it would hear both cases on a really expedited basis. It was not going to put SB 8 on hold while it hears these cases. It could have, but it didn't. Only Justice Sotomayor said that I want to put SB 8 on hold. What the court did was say on October 22nd, 10 days from now, on November 1st, we are going to hold oral argument on both the clinic's case and the United States case. This is very fast, lightning fast. Usually it's months and months between when the court decides to hear a case and here's the oral argument. But the Supreme Court said we're going to hear this on an expedited basis, recognizing the serious issues here. Unlike the Mississippi case, this case is not directly addressing abortion. The Supreme Court said we are only hearing the procedural issues. In particular, can the clinics sue the clerks and the judges? Is that allowed? And can the United States sue Texas directly for violating private citizens' constitutional rights? So the argument happened a week ago, or 8 days ago. The argument happened. All eyes were on two of the new justices, Justice Barrett, who I already talked about, and Justice Kavanaugh. Why the two of them? Well, the two of them were when the Supreme Court let SB 8 go into effect on September 1st, it was 5-4. The four in dissent were the three liberals, Breyer, Sotomayor, and Kagan, and Chief Justice Roberts. So presumably those four are going to continue to vote to hold up SB 8. So the clinics and the United States just need one more justice. And so the thinking was it might be Justice Barrett. She's new. We don't know how she's going to decide. Or maybe it's Justice Kavanaugh because he has shown some sense of concern about the institution of the Supreme Court and he might side with the clinics. So all eyes were on them during oral argument. And during oral argument, the two of them indicated some skepticism about SB 8. In particular, Justice Kavanaugh asked questions. Well, if a law like SB 8 can be passed around abortion, can it also be passed with respect to guns? So a liberal state can allow anyone to sue someone who sells someone a gun or aids and abets the acquisition of a gun? Or what about religion? Can there be lawsuits around religion? So he was concerned about the slippery slope of a law like SB 8. Justice Barrett asked several questions about whether the lawsuits that SB 8 allows, in those lawsuits in Texas state court, can a clinic raise all constitutional defenses in that lawsuit, or are they given limited option to raise their rights? And she was concerned that the law does not allow them to really raise their constitutional rights in these lawsuits that SB 8 authorizes. So the two of them were skeptical in that regard. But oral argument, sometimes judges ask questions that they don't really mean, or they're just probing the advocate's different positions. So we can't say for sure what's going to happen based on oral argument. And here we are 8 days later, and we still have not heard from the Supreme Court. The court recognized the importance of moving quickly to hear oral argument, but so far it has not decided this case. So we're 70 days into SB 8, 70 days into people who need abortions having to travel outside of the state or take their pregnancies into their own hands. 70 days with clinics closing because they can't operate doing the abortions for just under 6 weeks. 70 days of basically a constitutional right not applying to Texas. And the Supreme Court has yet to rule. It did look like from the oral argument that the justices were going to side with the clinics. At least a majority would. But what they do from there was unclear. Are they going to put SB 8 on hold? Are they just going to send it back to the lower courts? We don't know. They seemed all over the place about the remedy. But I think what was also clear is that the justices were thinking about SB 8 completely separate from Dobbs, completely separate from the Mississippi case. So it's very possible that the Supreme Court any day now strikes down SB 8 or puts it on temporary hold or gives the clinics a win. And yet next month, when they hear the Mississippi case, which is a proper case, which does not undermine the basic way we do law in this country, that could be what they are looking at to target abortion more generally. And you can imagine a world in which Justices Barrett and Kavanaugh, they've wanted to overturn Roe v. Wade, and SB 8 is sort of a pesky sideshow that they don't want to deal with. They want to get rid of SB 8 because that's distracting. They want to get rid of Roe the right way. And the right way is with this Mississippi case, where they can deal with a case that doesn't have procedural problems or these novelties, and is a more direct challenge to Roe v. Wade. And so it's possible that they could rule for the clinics in SB 8, but in the Mississippi case, be very skeptical and possibly sometime next year overturn Roe v. Wade. So there's a lot hanging in the balance right now in this very short period of time. And when we had scheduled, or when we were looking on the calendar and thinking about this, I was hoping that the Supreme Court would have ruled on SB 8 by the time we held this today, but unfortunately we are still waiting. So that's where we are right now.
Thank you both so much. Not good news, but important news. I think we'll jump in with some Q&A now, if that works for you both. Our first question asks, did Professor Joffe say that telemedicine was prohibited in 17 states for general health issues or only for abortion services?
Only for abortion services.
If I recall, I believe telemedicine was expanded for other services during the pandemic,
Right,
quite extensively. Our next question, my question has to do with Roe v. Wade and Obergefell v. Hodges. Both court cases are very much about personal sexual freedom. If Roe is overturned, what impact could that have on Obergefell and same-sex marriage?
This is an excellent question because not only do they both have to do with personal freedom, but they are both rooted in the same legal doctrine. There's a legal doctrine called substantive due process, which basically says that the Constitution's 14th Amendment, which prohibits denials of due process, that part of the Constitution prohibits the government from denying you fundamental rights. Now, of course, what's a fundamental right is the big question, but what the court has really done for the past 80, 90 years is say that fundamental rights are those that are really essential to how we define ourselves and how we define our family. And that can be related to bodily privacy, but it can really be about self-definition and sort of what part of our individuality do we need the government to stay out? And so the idea, so Roe v. Wade comes from that doctrine. And Obergefell v. Hodges, this same-sex marriage case from 2015, comes from that doctrine as well. If Roe v. Wade is overturned, and basically this Supreme Court were to say that we cannot find a right to abortion in the Constitution, because everyone agrees, you read the Constitution as many times as you want, it's not going to say the word abortion, it's not going to say the word privacy. These are implied rights. So if you say that abortion is not part of the constitutional rights around fundamental rights, well, then how can you say same-sex marriage is? You're basically knocking down these key precedents about personal autonomy. And if one falls, then you have to question whether others are going to fall. And in fact, one of the organizations, Texas Right to Life, filed a brief with the Supreme Court in, I think it was the Mississippi case. It might be the Texas case. I'm pretty sure it was the Mississippi case. They filed a brief with the Supreme Court asking the Supreme Court to not only overturn Roe, but to also overturn Obergefell v. Hodges, and possibly even overturn Griswold v. Connecticut. Griswold v. Connecticut is a 1965 case which said that states cannot ban contraception. So that's founded on the same principle. And basically, I mean, on the one hand, it's crazy and radical what they're saying. This idea that the Supreme Court's going to go back on this case that almost no one disputes, that a state can't ban contraception because 99+% of people in the country use contraception at some point in their lives. So in that sense, it's crazy and radical, this request. But on the other hand, it's legally logical that if they're going to get rid of Roe, then substantive due process as a doctrine probably needs to go. And so they're sort of laying all their cards on the table and showing just how radical this project is. We want to get rid of abortion. We want to get rid of same-sex marriage. We want to get rid of contraception. We probably want to get rid of parental rights to control their parents and let the state do that. We want to get rid of rights to procreation, rights to medical care decision-making. All of these rights would start falling if Roe v. Wade were overturned because they're all connected under the same doctrine.
Thank you. Abortion exceptionalism has allowed for a stark number of restrictions on abortion, especially in the Midwest and South. If Roe is overturned, how much will that affect these regions of the country?
And this question is to whom?
It's about abortion exceptionalism, so I think we'll aim it at you, Dr. Joffe.
Okay, if Roe's, excuse me, if Roe is overturned, there are a number of trigger laws on the books. The Center for Reproductive Rights has estimated, I believe, about half, I can't remember if it's 24 or 26 states would ban abortion. Some have trigger laws, some are expected to do that. So the abortion exceptionalism that I talked about becomes a moot point in that sense, that those states literally would not have any abortion legally happening within them, hopefully with the narrow exception of threats to life or health. I mean, there's a whole bunch of legal issues that then present themselves that I'll turn over to David. You know, will it be legal, for example, to go from one state to another to get an abortion? Will it be legal to take the first medication that's involved in a medication abortion? Typically, one takes the second medication 24 hours or so later. To give a very concrete example, if you live in Missouri, which is an extremely anti-abortion state, only has one clinic, most people in Missouri go to Illinois, drive across the bridge to Illinois and get their abortions there. Now, if they get medication abortion, as I just said, what is the deal here? Anyway, I'll let David finish this argument here.
I mean, one of the big problems is that we don't know the answers to a lot of these questions because we haven't been in this world. of abortion being illegal in one state and legal in others in 50 plus years. And we have seen already in Texas with SB 8, where patients are not only going to states that immediately surround Texas, so, New Mexico and Louisiana and Arkansas, but rather we're seeing states all over the country where patients are going because they're driving or flying or basically wherever they can find relatives to support them, they're going there. And so I think if Roe is overturned, we're going to see that kind of abortion travel expand, of course, for the patients who have resources and have the time and have the support to be able to do that. We're going to see abortion travel expand, and we're going to see aggressive anti-abortion prosecutors trying to stop people from traveling out of state to get an abortion, and to stop people from helping people travel out of state to get an abortion. And we'll be in this whole new world of aggressive regulation or prosecution of people sort of using their right to travel to benefit the different laws in different states, or to get the benefit of different laws in different states, and people trying to stop that. So I think that if Roe is overturned, that kind of sort of complexity of our state-based system of laws is going to just become a big issue.
Okay, this one seems pretty straightforward, and I'd like to know the answer too. What is the rocket docket, and how is it different from a shadow docket?
So the rocket docket is a term that's used by some trial courts to explain or to describe cases that they hear really quickly. And we're talking trial courts. So basically you file a lawsuit or you get charged with a crime, and rather than taking the months to years or many months to many years to have the entire trial, either a civil trial or criminal trial, some courts will put those cases on what's called the rocket docket, and they will hear them within weeks, or maybe a couple months instead of a couple years. That's a term used for trial courts. I've only heard that in trial courts. The shadow docket is a term used to describe the Supreme Court's practice of basically deciding cases that raise issues on an emergency basis. So the normal practice for Supreme Court cases is that you ask the Supreme Court to hear a case. It doesn't have to. It takes months before the briefing is done just in that part, and then more months for the Supreme Court to decide whether they're going to take the case. And then if they do, there's even more months for the full briefing on the case, and then more months to hear the case, oral argument, and then more months to decide the case. So the point at which you appeal a case to the Supreme Court and decision can be up to 2 years. That's a long period of time. A shadow docket are cases in which one party, usually a government act, usually some government actor, says, we need a quick decision from the Supreme Court for some reason or another. And it's often because someone is claiming that their rights are being violated in a way that we can't wait 2 years. Or it's because the government says, we passed a law, a lower court has struck that law down, and we have a right to put this law into effect. So we need that to happen now. We have seen an increased number of cases on the shadow docket in the past several years. And in those shadow docket cases, the court hears cases, or doesn't ever hear oral argument in the cases. It just takes a couple briefs in those cases, and it usually issues a very short, unsigned order allowing a law to go into effect or blocking a law from going into effect. And there's been a lot of criticism over the past year and a half that this conservative Republican-controlled Supreme Court has been using the shadow docket to make decisions that are not fully argued, not fully reasoned, but that align with Republican Party priorities. And so the court has been criticized for this. The first SB 8 case, where they basically were asked to stop the law before it went into effect on September 1st, was a shadow docket case. And the resulting order from the court was a 5-4 decision The majority opinion was 1 paragraph long. It was not signed by any justices, and the dissents, there were 4 dissents, and each were about a page or 2. Compare that to a normal Supreme Court case where majority opinions are 20 to 50 pages long, and the dissents are 10 to 20 pages long. You know, it's a very different sort of reasoning and analysis that goes behind those cases. So this court has been criticized for the its use of the shadow docket, you know, that's what happened with the first SB8 case.
Thank you. Let's see, our next question. In 1992, KCV Planned Parenthood established the undue burden standard, meaning that states may restrict abortion under certain circumstances but cannot block access. However, in states like Mississippi, there is only 1 clinic and multiple abortion restrictions. How does this not violate the undue burden standard? And I see both Carole and David laughing, so this should be interesting.
So I think that there's a couple answers to this question. The legal sort of doctrinal answer is that if clinics are closing, that's not the responsibility of the state. The right to abortion is not that you have a right to a clinic in your state performing abortions. And if clinics are making private business decisions, whether to close or stay open, and it results in a state having 0 abortion clinics, that is not a violation of the Constitution, because the Constitution does not guarantee that you have a clinic in your state performing abortions. Of course, if a state makes it very difficult for a clinic to remain in operation because it overregulates the clinic in a way that makes it difficult, scary, impossible to operate the business that is an abortion clinic, just like the business of a dermatology office or the business of any other doctor. If it makes it impossible for the clinics to operate because of the way it regulates, the argument is, as suggested by the question, that that's an undue burden and a substantial obstacle for the patients who want to have an abortion in the state of Mississippi. And that argument, there is a case going forward right now against the state of Mississippi, arguing that all of the restrictions sort of together, if you look at them collectively, that creates an undue burden, because not only does it result in only 1 clinic that only goes up to 16 weeks, but it also makes it really difficult for the patients who do go to that clinic to get an abortion. And that case is being litigated right now in federal court. But Dobbs has sort of jumped the queue to be decided before that case about all of the restrictions together. And that sort of, I think that case is on hold while Dobbs is being litigated, because if Dobbs turns out to overturn Roe v. Wade and Planned Parenthood v. Casey, then this other case is going to go by the wayside, because the basis of this case is Roe and Casey. So if Roe and Casey are overturned in Dobbs, then this case about sort of the collective burden of all of these laws together disappears.
Thank you. Abortion exceptionalism seems to create a sort of irrational overkill in abortion laws. How can we create a more reasonable approach to abortion?
Good question that people have been asking the 48 years since Roe was decided. No, I mean, that's a great question. And, you know, and there aren't, I mean, the only answer will sound very lame. And I feel embarrassed being in California saying this to people in Mississippi. Really, the only answer is to elect different people and not make it in the interest of legislators to vote. I mean, you know, we keep hearing again and again and again, you know, majority of American people do not want Roe overturned. Sometimes the figure you hear is as high as 70%. So and I think that's true. It doesn't mean that all these 70% necessarily have the same feelings about abortion. A lot of these 70%, for example, would be okay if there was less abortion after the first trimester. But we are a country that does want abortion to be legal. Therefore, the question presents itself: why is it very likely going to be overturned? And there's no simple answer. One answer, of course, is the very effectiveness of the anti-abortion movement, abortion becoming a central pillar of the Republican Party. To this moment, being against abortion restrictions works. And as long as it works, why would the people for whom it benefits, namely the people who get elected, want to change it? But I think to understand this in broader context, we are a low voting society. I mean, other countries have, literally 98, 99% turnout. We don't have anything near that. In a presidential election, it's a very big deal, if 60% of people, show up. So that's one explanation for the reason why, why these anti-abortion legislators keep getting elected. Another reason is that it's the intensity of the issue. A lot of people who are pro-choice, but that's not really their only issue. Contrast that with the anti-abortion movement, who are more likely than pro-choice people, I believe, to be single issue voters who approach this with a real intensity. Obviously, I mean, this Yankee is telling you people in the South that, you live in a very religious state. Not everybody who's religious is against abortion, but many people are. So I applaud the questioner for raising that issue. And I hope he or she or they have a lot of patience, because it's going to take a very long time to change the culture. I mean, one hope, and I don't know how realistic this hope is, that if the court overturns Roe, it will, it will provoke a huge backlash, and people will get very determined and say, you know what, we're not going to take this anymore. We're going to start at the local level. We'll only support candidates, who are pro-choice. I mean, that's a heavy lift. I hope that happens, and I wish I could be more upbeat to the person who asked that question. I mean, David, did you want to add to that?
No, I agree. I wish I could be more upbeat too. I mean, I think one of the challenges with the Mississippi case is that if the court wants to take sort of a middle ground, and I put middle ground in quotes, it could say, find some way to wiggle around and say, well, the Mississippi law is constitutional, but say nothing about overturning Roe. And if it did that, it wouldn't produce the headline of Roe overturned, but it would accomplish a huge chip in the armor of Roe and Casey. So it would make it easier to restrict abortion, but maybe not mobilize the people the way you just talked about, Carole. Because if there isn't that sentence, I think a lot of people worry, if there isn't that sentence in whatever the decision is in Dobbs that says, and now Roe is overturned, are people going to be mobilized? Because with that sentence, maybe people will be mobilized. But without that sentence, it becomes a complicated legal issue. Well, they didn't say they're overturning Roe, but they allowed this law. What does that mean? And we debate it and we debate it, and no one's mobilized. So I think, the real pessimists, the real pro-choice pessimists out there are saying that's what the Supreme Court's going to do, because it's going to give Mississippi the authority to restrict abortion pre-viability, but not say, and we're overturning Roe, and thus not mobilizing the resistance.
Yeah, if I can just add one more word of slight optimism. I think the culture is changing. I mean, popular culture. A lot of it driven by younger people. you know, we finally have abortion movies where you don't go to hell or die if you have an abortion. That's a fairly recent development. I urge everybody, if you haven't done so already, Google Saturday Night Live clown abortion. You know, comics are taking up, you know, the issue of abortion, which no doubt will offend some people, but will, I think, will encourage other people. So we are seeing, I think, little by little, you know, true cultural change. We haven't in this talk yet discussed the reproductive justice movement, which is somewhat apart from the reproductive rights movement. The reproductive justice movement, it's not only people of color, but it was initiated by women of color. It talks about abortion in the context also of having the right to have a child, as well as the right to terminate a pregnancy, the right to parent one's children in a dignified manner with the resources one needs. So there are things afloat in our culture, especially among younger people, that point to a change. Whether it'll happen in my lifetime, look at this gray head, I don't know. But I think the pendulum will eventually swing. How soon that will happen, not clear.
We're just about out of time, but we do have one last question, although it's a bit of a doozy. So here we go. How likely is it that Roe v. Wade will be overturned? And if it is, how can we reestablish a constitutional right to abortion?
Take it away, David.
I think that right now where I sit, I think it's pretty likely that Roe is going to be overturned. I think the way the court treated the right to abortion in letting SB 8 go into effect indicates that 5 justices do not believe this is a real constitutional right. If they had, they would have stopped SB 8 on September 1st. And the fact that they have now let SB 8 be in effect for 70 days and the people of Texas basically lose their constitutional right for 70 days, to me indicates that they do not care. And so I think that is more likely than not to happen. Now, Dobbs will be argued December 1st. We won't have an opinion until end of June next year. They will almost certainly take that long to decide the case. So it will happen in June, I think. What will have to happen to reestablish a constitutional right to abortion? Well, there's a few different things that could happen. All of them take political mobilization, the stuff that Carole was just talking about. One would be for Congress to pass a law that says that you have a right to abortion and that states are not allowed to pass laws that conflict with Congress. That requires getting rid of the filibuster or enacting or electing 60 pro-choice senators, because that law has passed the House, but it has no chance in the current Senate. So that's one option. Two, and that wouldn't be a constitutional right, that would be a statutory right, but it would have a similar effect, at least in the short term, because the statute can be changed more easily. Two, pass a constitutional amendment. Constitutional amendments, that's not happening. Let's be realistic. The Constitution is amended very rarely. We've had 17 amendments to the Constitution since 1791. There are some states, like where Carole lives, where the Constitution is amended all the time, the state constitution, but the US Constitution is rarely amended because it's such a heavy lift. The anti-abortion movement has been trying to amend the Constitution every year since Roe v. Wade, and they've never come anywhere close, even though they've been very successful in other political realms. It's just that difficult. So the third option is to pack the Supreme Court with pro-choice justices, because if Dobbs can overrule Roe, another case can overrule Dobbs. Just like we and by we, I'm talking about pro-choice advocates, we were worried for a long time that Justice Ginsburg was getting old and Justice Breyer is getting old, and they're abortion rights supporters. So too will the conservative justices. They will get old. They will not be able to serve on the court forever. And at some point they will be replaced. Now, we don't know when. Justices Thomas and Alito are in their 70s. They look fine now, but who knows how long, right? Everybody fails. And we don't know when that's going to happen. The reality of it is we have no idea when any one person is going to stop being able to perform their job, just because that's the nature of having a body. And so when that happens, if the Democrats or pro-choice politicians have control of the Senate and the presidency, and they make it a priority, getting back to Carole's point about the priorities of the different sides, they make it a priority of putting into office, or the Supreme Court, justices who are pro-choice, then Dobbs can be overturned, because the basic rule of constitutional law is being able to count to 5. If you can count to 5, you win, because 5 beats 4. And so if there are 5 justices who have the motivation, the ideology, the judicial temperament, the politics to overturn Dobbs, then Dobbs will be overturned. And so it's paramount for pro-choice people, if Dobbs is overturned, to put every pressure they can on whoever's in the Senate and whoever's in the presidency to appoint pro-choice justices when that opportunity comes around. Which is why presidential elections matter so much, which is why Senate elections matter so much, because that will determine who has the power to appoint the next set of justices. And there will be a next set of justices. That's just a reality. So, you know, in a way, everything on the Supreme Court's temporary or could be temporary, because the next set of justices can change that. And if there's something we're really upset about, that's what we have to focus on in terms of getting the next set of justices to care about.
Dr. Joffe, Professor Cohen, thank you so much for taking the time to be with us here today. I know this is a very busy time in the semester for everybody, but thank you for visiting with us and helping us to make sense of a climate that is rapidly changing, confusing, and contradictory. So we appreciate you being here.
Thank you for having us.
Yeah, thank you. Absolutely. This was great.
Yep. And if I can just add my thanks as well, the Institute for Humanities tries very hard to have these kinds of live WebEx forums as a way for, people, normal people like myself, to understand better what is going on so they can take a more active role in their situation and to have a chance to ask questions and converse about things. And you've provided that brilliantly here. So thank you very much. And thank you again, Dr. Kelly, for bringing this program together. Thanks. Bye-bye.